I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So we've got 2 DWS files, correct?
Over and another who's in board status, but I think we're here on this motion hearing.
Yeah, so one file's a money issue. The old one from December 2016, that's a drove while license suspended. The file shows you owe money.
Yeah.
Right, all right. So we'll talk about that one. All right, and then you filed a motion on the case from November of 2025, correct? All right, give me a minute to look at the paperwork. Okay, I did see Mr. Blade's motion. I did have a chance to see that, read that one already. So I'm going to read the people's response.
All right, guys, let's break this down. The judge wastes zero time entertaining legal gymnastics. The defendant tries to argue the suspension was invalid, but the judge cuts straight through it. Suspended means suspended at that moment. It's a brutal reality check. This isn't theory class, it's enforcement. Right away, you can see the gap between what the defendant believes and how the court actually operates.
Okay, I've had a chance to review. So anything you want to add to your written brief?
It's showing that there was no personal jurisdiction when the court lacked the authority to mayor of judgment or default judgment.
You're talking about the Monroe case?
Yeah.
Okay, go ahead.
They lacked jurisdiction in order to make that case or make a judgment for.
Anything else?
Can't find them any between who service and collective. I saw people started from part of
Just to be clear for the record, we're still talking about the Monroe case?
Yeah.
Okay, go ahead. Right.
to ask for proof of service that were unable to provide it.
Right.
They told me that it was for the sheriff. So I went over to the sheriff's office to ask for proof of service because that service.
Right.
Because I never received the notice to appear in court, so I had no idea that we were charged with it again.
Okay.
And going forward, I go to the sheriff's office. I ask for the proof of service from the sheriff's secretary Bird. I'm not sure if that's the order of position or if she's at line of text. But she noticed that the ticket had the officer's name.
The defendant shifts into explanation mode, throwing in claims about lack of service and confusion around the Monroe case. It sounds detailed, but it's scattered. He's trying to build a technical defense, hoping something sticks. The problem? He's arguing complexity in a room that values clarity. The more he talks, the more it feels like he's drifting away from the core issue instead of tightening his position.
Which happens to be now currently the defendant. He come out and spoke. He said, I don't remember this ticket. I don't even believe I was, I don't even believe I was on that shift at this time. A few things that he mentioned to me. So I wasn't prepared for this. I was studying everything supposed to be correct. When he spoke to me, I took what he said and I said, okay, maybe I can get him to fill out an affidavit.
Right.
The things he said, I'm not asking him for anything in my favor, just what you recall, all I want. He didn't respond in time. He mentioned that he would have no problem speaking to the court here for the last case. But I didn't receive that response to the court. But he went through my motion. The officer said he believes that I did have insurance, but I was a police show force. having me notification with the courtroom to be there, nothing. It's prison charge.
Okay. Anything else? Anything to add to your written response that I just read?
Now he leans on the officer's lack of memory and hints at having insurance, trying to poke holes in the situation. It's a classic move, attack the gaps. But the court isn't biting. The argument lacks force because it doesn't directly dismantle the charge. Instead of weakening the case, it comes off like a distraction, and the judge is clearly not losing focus.
The court is well aware that this court doesn't have any jurisdiction over a no proof of insurance citation that was issued by Monroe County Sheriff's Department in 2005.
All right. Mr. Blade, I've got a question for you. Do you know whether or not the Michigan Secretary of State listed you as a valid driver on November 29, 2025?
No, that's not good.
Okay. So if I told you the Secretary of State record showed you were suspended on the day that Officer Haydenack stopped you, you would have no reason to take issue with that fact? If I told you that your driving record listed you as a suspended driver on November 29, 2025, you have no argument one way or the other whether or not that's the case. No, that's all right. I don't want an answer if you don't understand the question. If I told you your Secretary of State driving record showed you as a suspended driver on November 25th of 25, would you have any reason to deny that as factually correct?
The judge flips the script and zeroes in with a simple question. Was the license suspended or not? Suddenly, all the layered arguments collapse into one unavoidable point. The defendant hesitates, dodges, and that hesitation says everything. In court, clarity wins. And right here, the lack of a straight answer starts doing real damage.
Okay. All right. So I'm going to deny your motion for two reasons. Number one, his actions are based on what the Secretary of State says, not what the Monroe County Sheriff's Office says. B, I don't have the authority to do what you're asking me to do, because if I understand the situation, your Monroe case has been completely adjudicated in Monroe. They've left that on your record. I don't have the authority to change that record.
That's not what my motion is asking, but I'm only asking you if you would recognize the jurisdiction. That's all I'm asking.
I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So my ticket, the Huron Township ticket, is a perfectly valid ticket moving forward.
But the jury,
Decision time. The judge shuts down the motion cleanly, reinforcing that Monroe County isn't the authority here. The Secretary of State is. It's a firm reminder that jurisdiction matters more than personal belief. The defendant's argument doesn't fail because it's emotional. It fails because it's aimed at the wrong target.
Gather your thoughts. I'm not in any hurry. These kids want a show.
default judgment issued without prior notice can be deemed as a violation of the party's rights to due process.
Absolutely. Absolutely. But not by me. I can't override the Monroe Court. Now, I can take all this into consideration when I sentence you on this file, but I can't set aside what happened in Monroe. Okay. Okay. Are you just seeking to mitigate your damages here? Are you just seeking to mitigate your damages in this court based on what happened in Monroe?
Monroe is the reason I'm here. So
Absolutely.
we can't separate the two because it's the Monroe charge that got me of driving without.
Right.
That got my life.
Right. I understand that.
I did issue. Which absolutely would you like to see that?
No. I'll for today's argument, I'll take your word for it.
The defendant doubles down, now framing things as rights violations and due process failures. It sounds serious, but the judge doesn't budge. He acknowledges the concern but draws a hard boundary. This courtroom isn't the place for that fight. It's a reality check. Having a grievance doesn't mean you're in the right venue to fix it.
Didn't actually have issues,
Right.
but I didn't have an opportunity to defend, to show the court that I had issues. So going to jail and then to prison right behind it, when I come home, I'm trying to get my life together.
Okay, well, first of all, I can't speak from personal knowledge of Monroe, but every court I know of on a civil infraction, they don't send a notice out on the civil infraction. The ticket is your notice that you've got a problem you got to deal with.
But I didn't receive it. I went to jail that.
So they never handed you a ticket? Okay. Well, then you got a problem, but I can't fix it. I don't have the authority to fix it. If we have a trial on today's DWLS case, as prosecutor, she's going to have to prove to me that on November 29, 2025, your driving privileges were suspended in the state of Michigan. And she's going to have to prove to me that you were driving a vehicle on that date in Huron Township. If she proves that to me, I'm finding you guilty of drivable license suspended, revoked, or denied. The fact that the Secretary of State shouldn't have suspended you does not change that at all. You were suspended.
The judge simplifies everything to its core. If you were suspended and you were driving, that's the case. No philosophical debates, no side arguments. It's stripped down to pure legal mechanics. The defendant's broader narrative gets boxed out completely, and now it's clear. This is about facts, not interpretations.
Not Monroe screwed up or they didn't screw up, you were suspended. So I'm denying your motion. Okay? I'm assuming we can have some pretrial conversation.
And you're,
Okay.
like, if one wishes to plead to the drivable license suspended, I will dismiss the two remaining.
And I don't even have the remaining charges, so are they already in default? Or did I just not get the files?
There's vehicle and another misdemeanor registration title among 50.
Oh, I'm sorry, I was looking for civil infraction. Okay, all right. Do you want to avail yourself of that offer? He will dismiss 2 misdemeanors if you plead to the drivable license suspended. So the misdemeanor unregistered vehicle and the plate or registration violation misdemeanor, right, those 2, would be dismissed if you plead to the drivable license suspended, revoked, or denied.
Leave that open.
The hallway is yours. Yeah, go take a minute. That's fine. Why?
Start at 9:16, end at 10:22. Now comes the pivot, strategy over argument. The prosecutor offers a deal, plead to one charge, drop the others. This is the moment where reality meets risk. The defendant has to decide whether to keep fighting a losing uphill battle or take a controlled outcome. It's less about justice now, more about damage control.
Research.
You no objection to another? We'll adjourn it. Oh, I don't care. March 12th, give you enough time?
Yes.
Okay, so Heather will prepare a notice on that one. Now, as to the December 1, 2016 file, our records show that you owe $840. Are you in a position to make some kind of a payment plan on that?
But I haven't money back. I currently don't have any money.
All right, you're confused. You don't have any money today?
Yes.
All right, but you could commit to some regular payments and make them. How much, how often, when do you want to start?
But I don't make very much money.
I need you to make some kind of commitment today if you can. You don't have to start it today.
It shows that.
Okay. How much?
The judge pauses the pressure and gives the defendant space to think. It's a rare moment of calm in an otherwise direct exchange. But make no mistake, this isn't leniency, it's procedure. The clock is ticking, and the next move will define how much this situation escalates or settles.
No, I'm not paying a clerk to process a dollar payment. But I got to get something going. How's this? When's the last time you worked? Where do you work? Walmart?
Or
Cormart, what do they do?
they,
Okay, full-time job? Okay, can you pay $50 a month? Start when?
The focus shifts to money, old fines, unpaid obligations, and accountability. The judge gets practical fast, pushing for a payment plan. This is where the system tightens the screws in a different way. Legal arguments fade, and financial responsibility takes center stage. No escape here, just structure and expectation.
First Friday of March is the 6th, and that's 2 weeks out. Can you do that? 50 a month. We'll always take more, so if you want to pay extra. $50 a month, starting March 6th. Yes? Agreed? Okay. We're getting you notice on that other court date. Have a good day.
Yeah.
You're welcome. Officer Haydeck, always a pleasure. Be safe.
The hearing wraps with a $50 monthly payment plan, and the defendant finally aligns with the process instead of resisting it. After all the pushback, it ends not with a dramatic win, but with compliance. It's a quiet but telling finish. Sometimes the system doesn't need to overpower you. It just waits until you run out of angles. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.